Welcome to episode number 218 of AAA Weekly Knowledge Series. The topic that we are going to discuss today is a kind of resolution for various real estate cases. The judgment of Honorable Supreme Court dated 5th May 2026 is a landmark judgment which will resolve issues only for various stalled projects, and those issues this judgment will resolve it. There are many cases where the land owning company is different, the developer is different. So this judgment is instrumental in handling that, and most of these cases will be resolved. The citation of this judgment is Alpha Corp Development Private Limited versus Greater Noida Industrial Development Authority. We will call as Alpha, and Greater Noida Industrial Development Corporation we will call GNIDA. So this is the word that we will use in this judgment. Now, first of all, so this is a case, in fact, which started, the CIRP started long back, and these resolution plans were also approved. Resolution plans were also approved in 2019. Some time was taken by ANCLAT, and then some about 3 years were taken by Supreme Court. So therefore, the total 6 years litigation, the GNIDA, there are other issues regarding project-wise insolvency. There are issues regarding the dissenting creditors in a class. All these issues are resolved. So in this case, 11 civil appeals were filed before Honorable Supreme Court, and these civil appeals, like I would just brief a little. One is a successful resolution applicant. Basically, there are two resolution applicants in this case. One is Alpha and the other is Roma. Alpha is trying to resolve 3 projects of this company, which is the corporate debtor is Earth Infrastructure Limited. So this is very important that first of all we should understand the total parties in this case. So the first is the corporate debtor, which is the Earth Infrastructure Limited. In short, we can call it as EIL. And the other is the Earth Town Infrastructure Private Limited, which is again one of the subsidiary of EIL. So EIL is the Earth Infra is the corporate debtor. So this ETIPL, Earth Town Infrastructure, is one of the lessee. Neo Multimedia is another lessee. Nishida Software is another lessee, and Orocum Buildtech is another land owner, but that land is a freehold land. So there are total 4 projects. Out of the 4 projects, the 3 projects are on leasehold land from GNIDA, and 1 project is on a freehold land. 2 resolution applicant, one is Alpha, giving a resolution plan for 3 projects, 2 on leasehold land and 1 on freehold land, and 1 is Roma, giving a resolution plan on 1 project which is on leasehold land. So Ankit, in case we are clear about the parties, so then we come to know about the various parties who actually in fact have filed civil appeals before Honorable Supreme Court. One, of course, Alpha, and one Roma. These are the successful resolution applicant. Then the one is the authorized representative of monitoring committee. Then the corporate debtor has also filed, and there are some homebuyers associations, and Greater Noida, like GNIDA, has also filed. So these are various the civil appeals which has been filed. And in case we have to talk about the respondents, most of the cases respondent is GNIDA, and in some cases also some like RP and they're all made interveners.
So important to add here that the overall structure with respect to how the development agreements and the leases were structured, it is important to understand that Earth Infrastructure Limited, the corporate debtor which went into insolvency, had the development rights for all the projects that we're talking about. 2 of these projects were on leased land from GNIDA, where the lease was not in another non-related entity. The lease was in a subsidiary of the, or 2 subsidiaries of this CD itself. And another land which was for the Gurgaon project, there again the land was held in the subsidiary, but the project was actually being executed at the holding level. it is also important to understand that these three subsidiaries were merely land owning agencies or land owning companies or land holding companies, lessees for GNIDA. They did not have any other business that they were conducting other than just land holding.
Yes. So what Ankit is saying is, only to clarify, that there are many such cases in Delhi NCR where the land rights, may it be freehold or leasehold, is sitting with one company, and the development rights are sitting with the other company, and both the companies are either holding or subsidiary relationship or associate relationship or within the same group relationship. So this is one of the very important issue which has been resolved.
We can perhaps add that why do we think this happens? Why is it that sometimes the lessee from GNIDA or other land holding companies are separate, although they are part of the same group?
No, it is basically the land allotment. Land allotment process is totally separate. Whenever the land is being allotted by NOIDA, Greater NOIDA, or any other real estate development agencies, it is being allotted to different companies on some parameters. Now, some companies want to develop their project in its own, with their own efforts, and some companies would like to find out a builder. And in some cases, this relationship would be on sharing basis. Like in this case also, although it is between the subsidiary companies, but there is a sharing ratio also. So what is the sharing ratio? Like different sharing ratio in all the cases. Like the company having the leasehold rights will have some percentage share in the space, and the developer will have the some percentage in the space constructed, and all the efforts and marketing and investment will be made by the builder, which is in this case earth infrastructure, which is the corporate debtor.
I think it's important to add that where both the companies, the land holding company and the developer, are part of the same group, the idea is very clear that the land allotment might have happened to different promoters of that company which have the lease in their name, and then subsequently the same might have been transferred. And several times the consideration that is paid for transfer of a company's holding, the land owning company, might have made over a period of time after the new developer came into being. So that maybe that did not allow the developer to be the same as the land owning company in these cases. We have examples where the developer is also the lessee from GNIDA. We have examples where the developer and the land owning company are not from the same promoter. They are different. But here we are very clear that as on the date of CRP initiation, the land owning entities were subsidiaries of the CD. They were not only related, or they were not only part of the same group. They were also subsidiaries.
So I would also extend this argument a little further. What Ankit is saying, that the land is basically on lease with a company and the development is being done by another company. No, both these companies taken together collectively are developing a project. Now the project went into insolvency, in difficulty, and it has to be resolved collectively. It is not possible to resolve the lessee first and then the corporate debtor, because once the building is created, then the land actually ceases to have any existence, because the land doesn't exist if the building is constructed. Then whatever is constructed will be sold. So in case any project, like I would extend this particular judgment that it will be applicable to all those cases also, where the land owning entity is different and the developer is different, and maybe they are related or not. It is one project. So the Supreme Court has actually indicated that the project has to be resolved, and while the project are being resolved, the land owning company or the lessee will also go along with the resolution plan. That is what is the real intent of this judgment. Otherwise, the project would not be resolved. It may have so this is what is also extended argument, Ankit, what I'm trying to say. Otherwise, if the corporate debtor, now think of a situation, and in this case, if the earth infrastructure is resolved and all the homebuyers will get properties, units, flats, plots, and all the creditors will be resolved, what would be left with the lessee? The lessee has got nothing in hand because the project is resolved, the homebuyers have got flats, the creditors have got their dues, and what is left with the lessee? Because see, the lessee has just some paper left with him. So therefore, it is the Supreme Court has rightly said that when we are resolving a project, it has to be resolved collectively. Now, in this case, the Supreme Court has not discussed anything like whether something will be payable to the subsidiary companies which are lessee or not. That is not something which has been decided, but it actually has to be resolved collectively. That is what is decided. And that actually will depend from case to case basis whether something is payable to the subsidiary company or to a third party company who has the land rights, who has the land ownership. So that actually can be separate. But this actually can be very clear that this project resolution actually will include land rights and the construction rights. That's what is the most important part. So there are various cases where both the entities are different. So these all are actually can be clubbed together for a resolution of a project of real estate.
We can briefly discuss what happened at NCLAT, which the Honorable Supreme Court then took decisions on.
Yes, yes.
So at NCLAT, the principal bench heard this matter, and it was various issues were framed and decided on. So three issues 1, 2, and 3, which NCLAT had taken up were whether the leasehold lands held by EIL subsidiary could be treated as the corporate debtor's assets in its CRP. That is the scope of assets under explanation to section 80. That was first question, or first issue. Second issue was whether resolution plans could deal with or provide for transfer of those leasehold rights without GNIDA's prior permission. Then whether this was a fit case to lift or pierce the corporate veil between EIL and its subsidiaries. These three issues, what the NCLAT said in their order was that these three issues, they decided that the assets belong to the subsidiaries and the assets could not be made part of EIL's resolution plan. And they said that in this case, since GNIDA was not a party to the development agreements or MOU between EIL and its subsidiary lessees, the NCLAT held that GNIDA was neither a creditor of EIL nor a stakeholder in the plans and was therefore not bound by them. So this is how they decided issue numbers 1 to 3. With respect to veil lifting also, the NCLAT declined to pierce the veil based on various previous judgments that it quoted in its order. And this was issue numbers 1 to 3. Issue number 4, with respect to the idea whether GNIDA was a necessary party or creditor entitled to be heard before plan approval and whether its belated claims could be entertained. So here again, what NCLAT said was that necessary party GNIDA ought to have been a party to the CRP and heard before approval of a plan dealing with its project lands. So this is how issue number 4 was taken up by NCLAT. Issue number 5 was whether GNIDA could levy penal interest, penal charges, time extension penalties given its conduct. So it says,
I think this is absolutely fine. The NCLAT has actually denied on certain issues and has agreed for certain issues. But finally, NCLAT has finally held that the restored the plans and it remitted the process. The RP together with the Buyers Association was to apply to GNIDA for permission to transfer the land. So like this particular part that the RP along with the Buyers Association will apply to GNIDA for transfer of lands which is presently in the name of the subsidiary companies to the corporate debtor. So this part was challenged. GNIDA could enter into an arrangement for payment of its dues and then transfer the lands. So this was another issue which was open for a lot of litigation, what kind of dues and how the settlement would be done. And the RP was to publish a fresh Form G. This was also challenged with plans to be placed before the COC only after GNIDA's dues were paid and its transfer permissions obtained. Now, this decision of NCLAT, first of all, the lands to be transferred by GNIDA would have never resulted into any positive outcome. First of all, the GNIDA's dues will be paid, then only the resolution plans will be submitted for approval. That is also something which is not doable. Roma and Alpha, the present resolution applicant, were permitted to file fresh plans. GNIDA was to recalculate its dues without penal interest and was made a party to the CIRP entitled to participate going forward. The steps were to be completed within 6 months, so therefore the appeals. Now the appeals, everyone was challenging. There are 3-4 directions given by ANCLAT. One, for land transfer, go to GNIDA. Before the land transfer, all the dues would be paid to GNIDA. Who will pay? Only after that the resolution plans will be submitted. So all this was a very, very kind of issues which would have never seen any resolution. Now this, before the Honorable Supreme Court, Ankit, it is very important that we should touch base what were the issues framed by them. I will just see the issues framed one by one. So the issues framed before the Supreme Court was whether the leasehold land held by corporate debtors subsidiaries like the NIDA, the 3 subsidiaries, could be treated as the corporate debtors' assets in its CIRP, the scope of assets under explanation to section 18 of the code. So this was the first legal issue. Second, whether the resolution plans could deal with to or provide for transfer of those leasehold rights without GNIDA's prior permission. See, the land and the project, both has to go together. Wherever it goes, it has to go together. And this was the second issue, whether the resolution plans could deal with asset which is not in the name of the company, the corporate debtor. The asset, the leasehold rights are in the name of a subsidiary company or a holding company, whatever it case may be. Whether this was a fit case to pierce the corporate veil between the EIL, Earth Infrastructure, and its subsidiary companies. Next issue was whether GNIDA was a necessary party, creditor, entitled to be heard before plan approval, and whether its belated claim could be entertained. Now, Earth Infra is the corporate debtor, and the NOIDA has no claim on Earth Infra. NOIDA has claim on all the 3 lessees, and those lessees have entered into a development agreement with Earth Infra. Now, the NOIDA cannot file a claim in the CIRP of Earth Infra because there is no contractual arrangement between AIL and the NOIDA. The subsidiary companies are not in insolvency. So therefore, Greater NOIDA did not file its claim. Now, this was also one of the issues, whether in case it files the claim, belated claim, could it be entertained? Now, the next issue was whether GNIDA could levy penal interest, penal charges, time extension penalties, given its conduct. Next, whether dissenting individual homebuyers within a represented class have locus to challenge a plan approved by the class majority, and then whether Alpha's plan was severable so that Earthcopia. Now, Alpha's plan has 3 projects, and out of the 3 projects, one was on a freehold land. So it was in fact requested to ANCLAT that that part of the resolution plan should be severed, it should be separated, and that should be allowed to be implemented. So that was not agreed by ANCLAT. So these were all the issues before the Honorable Supreme Court. So Ankit, can you touch the arguments, which is like all the appellants collectively? What kind of arguments were taken by the applicants collectively?
So to start with, I can talk about how it was contended by the plan supporters or the appellants that ETIPL was the alter ego of EIL, that is the subsidiary holding the land was an alter ego of EIL. They said that common directors, common promoters, no independent business, and EIL held 98% of this company, making it a fit case to lift the corporate veil. And this was the argument that was made, that GNIDA itself mandated the SPC structure for the project to kind of continue or take off. Then they said GNIDA was fully aware that EIL was the real developer, evidenced by GNIDA's own letter to the SSP, Gautam Budh Nagar, naming EIL as carrying out the construction, and EIL sourced certification submitted for building plan approvals. Then GNIDA was duly informed of the CRP Alpha's plan was approved by 91.39% vote, COC vote. GNIDA filed late and only with displaced IRP. So there was a committee of errors here. The GNIDA filed their claim even when they filed it on a belated basis with the IRP and not the RP who was conducting the process. Earth Copia, they said the freehold land had no GNIDA nexus and Alpha's plan contained a severability clause so that NCLAT erred in setting aside the whole plan. So again, a very, very big contention that was that, okay, maybe some of these lands were affected by GNIDA's contesting the land ownerships in the subsidiary not being part of the plan. But this one resolution plan for one part of the project or one Gurgaon project, they said should have been taken care of. Dissenting home buyers within a class are bound by class vote under section 25A. So they said even in case some of the home buyers are dissenting, their dissenting vote does not count because as per the regulations, they said if more than 50% of the home buyers are voting for a resolution, there is effectively no dissenting vote and that does not count.
No, in most of these arguments, there was only one party to contest it. That was GNIDA, like Greater Noida Authority. Now, the Greater Noida Authority argued vehemently before Honorable Supreme Court, saying that a subsidiary company is a separate entity altogether. Its leasehold land cannot be treated as the holding company's assets in CIRP. As per law, it is correct that the subsidiary company's assets are not supposed to be treated as assets of the holding company. Relying on Vodafone, JP Kensington, MCGM, they also quoted various case laws. We'll come to the case laws also. Then the Greater Noida Authority argued that the leasehold lands were never Earth Infra's assets and were rightly excluded from the information memorandum. The plans could not transfer title or leasehold rights without GNIDA's prior permission under the lease deed. Then it continued saying that the GNIDA was not a creditor of EIL, as I just said, nor a stakeholder in the plans, and was therefore not bound by the resolution plans. It ought to have been impleaded and heard. Its lease terms are sacrosanct. The Noida Authority continued saying that its lease terms are sacrosanct. It issued multiple default notices and was entitled to its dues, including penal interest, penal charges, and time extension penalties. It also said that as per Prabjeet Singh Soni judgment of Honorable Supreme Court, the GNIDA is a statutory authority under Section 13 capital A of 1976 Act. GNIDA is a secured creditor with a statutory charge on the leasehold rights as per Prabjeet Singh Soni judgment of Honorable Supreme Court. The court, in fact, all these arguments in between, the court also noticed that these are they are internally contradicting, because if they are using some part which is beneficial to them and they are leaving some part which is not beneficial to them. So the legal term it is called approbate and reprobate. So they also use this word approbate and reprobate. So that is the conduct of GNIDA in this case. Now, like we also would like to see, there are many cases which has been used in this case, but then we are not touching as of now the various cases. We are in later we will discuss about what various precedents have been used. Now we actually should discuss on each issue what was held by Honorable Supreme Court. I will touch the first issue, which is the lifting of corporate veil. When we say lifting of corporate veil and the disagreeing, first of all, the Supreme Court disagreed with NCLAT on this issue. The court held that this is a fit case to lift the veil. After citing the Constitution bench in Escorts, the court observed, because this was an original case of Escorts where the corporate veil was lifted, the court observed that the corporate veil may be lifted where a statute itself contemplates lifting the veil, or fraud or improper conduct is intended to be prevented, or a taxing statute or a beneficent statute is sought to be evaded, or where associated companies are inextricably connected as to be in reality part of one concern. So when we read the last line of Honorable Supreme Court judgment of corporate veil lifting in the case of escorts, that is what is applicable in this case. Where the associated companies are inextricably connected as to be in reality part of one concern. Now in this case it is part of one project. Land rights and the project both has to be resolved together. So therefore corporate veil has to be lifted, and then applying the ArcelorMittal judgment, and on the fact it concluded in paragraph 56 of this court judgment that given the facts obtaining presently, we are of the firm view that this was an eminently fit case for lifting the corporate veil, as Earth Infra was the main driving force in the development of the project and in payment of GNIDA's dues. The subsidiary companies were only a front. So, having held so, the court deemed it necessary to decide Section 18 and Section 25 asset question. So, therefore, the Honorable Supreme Court said that under Section 18 of the Code and under Section 25 of the Code, the leasehold rights with the subsidiary companies can also come under the definition of assets, which actually would be under the control of the RP and would be included in the resolution process. Now, the second was very important, and this actually will give us some education as resolution professionals, that this is something that we should look into in future. The court found GNIDA the author of much of the litigation through persistent inaction. That is what is written in paragraph 49 of the judgment. The court said very clearly that the GNIDA's action does not entitle them any interest. And the reasoning given by the court is, we are therefore of the opinion that GNIDA contributed greatly to the present imbroglio by its persistent inaction and inaptitude all through. It further said on GNIDA's attempt to portray itself as a victim. The court said, having allowed so much water to flow under the bridge, the GNIDA has allowed so much water under the bridge, it is not open to GNIDA to portray itself as an uninformed and injured victim at this late stage. The court accordingly affirmed that the ANCLAT on penal interest, in fact, ANCLAT also agreed that the GNIDA should not be entitled to any penal interest. But I believe it is not only a question of penal interest. There are many kinds of claims which the GNIDA has. One is the original, because see, in all these cases, 10% of the lease premium was paid and the rest of the lease premium was to be paid in installments. So most of the builders, most of the lessees paid some part of the lease premium and the rest of the part was defaulted. And in that particular allotment process itself, there was some clause in case some of the installments are not paid, there will be some interest that was already there. So the court has said that all that interest which is there in the contract is okay, because this was a structure in such a manner that the land was almost allotted in installments. So if there is a delay in installment, that interest of course is entitled to GNIDA. But then the court also said that the GNIDA's inertia means inaction, and failure to protect buyers clearly disentitles it from levying penal interest, penal charges, time extension penalties at this stage, while preserving its rights to recover the principal dues. Now, when the word principal dues is used, this principal means the original lease premium, the original lease rent, and along with this original lease premium and lease rent, the interest as per the document, interest on delayed installments and interest on non-payment of lease rent, which is annual lease rent. However, there are other components. One, it was also approved like the additional compensation to farmers was also considered as part of the principle. That's what because it is not written in the judgment, but when I see the outstanding, I will just come to the little bit of, because see what finally the what is allowed? What is allowed in case we see there is a specific figures given in the order, and in the figures, like in case we talk about the Neo Multimedia, the total dues claimed were 31.82 crores, and the principal amount was found 17 crore because penal interest on premium, lease premium was waived, penal interest on additional compensation was waived, time extension penalty was waived, so the balance was 17. Similarly, in the case of Nishitha, total amount was due of 17 crore, and the amount finally, the principal is about 7.95 crore, because all these four components, penal interest on premium, penal interest on additional compensation, time extension penalties, and penal interest on lease rent, these four things were waived. And then finally, in case we see the last project where 309 crore was the dues, and the principal is approximately 250 crore. Like in case we see the original lease premium, that may be even 50 crore. But this 50 as against 250, that means all other interest compounding effect is allowed to be taken by the GNIDA. So Ankit, when we say this, in fact, I have just touched the GNIDA in action. I think there are other issues which has been held by Honorable Supreme Court, which you can take up.
So another issue that the Honorable Supreme Court has clarified is that the ownership remains with GNIDA and buyers become sub-lessees. So the Honorable Supreme Court has said that that the plan transfers only possession and development rights, not the title. Ownership of the land remains with GNIDA and buyers take only as sub-lessees, which neutralizes GNIDA's apprehension that its land was being alienated. So that is how the Honorable Supreme Court differentiated that GNIDA is not being alienated of the land that it owned. The GNIDA had subleased it, and all the home buyers are effectively subleasing it, and that's where the differentiation was made.
But that is always, Ankit, because if there is a 99 years lease, the authority will always remain as the owner of the land, and the allottee will only have the leasehold rights. It is simply clarification, but this law is very clear that the ownership is not being changed. The land is not being transferred. Only the leasehold rights are being transferred along with the project.
So GNIDA in this case has been showing to NCLAT, to the Honorable Supreme Court, that it's a victim. It had land, it had given it on lease.
You're right.
It did not get its lease in time, and therefore, its rights on the land are being snatched by other parties without them being a stakeholder. That is the way GNIDA was representing itself. That's why you have other aspects also with the Honorable Supreme Court has said that one moment you say you are a creditor, your rights are affected. The other moment you say, no, I am not a creditor, I am outside the ecosystem of this project. So that's where I think this differentiation is important.
Reprobate.
Yes. So then you have dissenting home buyers within a class. So the court has very clearly said that section 25A subsection 3A, read with all the other provisions, is very clear that the moment the authorized representative casts the vote with more than 50% majority, then the decision of the minority or dissenting financial creditors does not come in at any point in time. So the whole provisions, how dissenting financial creditors is looked at, I think this can be revisited here. The dissent is not there. So in case you look at the regulations, even the amended regulations which talk about the rights of a dissenting financial creditor. So those dissenting financial creditor rights, the court has said that they don't have any locus here, because the voting that is being done is simply by a 50% or more majority, and therefore dissenting creditors won't have a place to kind of exercise or say that no, we should have gotten more, our rights have been taken away. They can't say that.
In a creditor in class situation, yes, anyone who is not voted for that resolution or resolution plan, but if more than 50% of class members have voted, then the rest of the members who have not voted would not be considered as dissenting creditors as per the law, as per the resolutions. So those dissenting creditors, individual dissenting creditors would not have their claim separate than the class of creditors.
Next, the court, the honorable apex courts said that because Earth Copia stood on a freehold land with no GNIDA nexus and Alpha's plan was severable, the enclad erred in setting aside the entire plan. The court found considerable force in this and preserved that part. So basically, the court, although in this entire operative instructions now, the court once said the resolution plans of Alpha and Roma are restored, project timelines to commence from 1st of June 2026. Then it says GNIDA to recalculate and communicate principal dues, net of penal interest, charges, time extension penalties to Alpha and Roma within 2 weeks. Then it said Alpha and Roma to clear those dues themselves in EMIs over 24 months without burdening home buyers or office buyers. First payment on or before 7th July 2026. And here again, based on an affidavit from the SRA, the court said that no, this is something that will not be passed on to the home buyers. The SRA has chosen to take a hit and go ahead with the implementation of the resolution plan with this change in the payment plan or with this change in how much is required to be paid to GNIDA. Then no interest is payable to GNIDA for 24 months extended period given its responsibility for the litigation. So the apex court said that 24-month extension that has happened in the last 24 months, that extension GNIDA will not claim any interest at all because it is in a way a penalty on GNIDA that because the delay was due to their litigation, that's why they have penalized or rather asked GNIDA to give a lesser claim in that fashion. Registration of units in favor of allottees only by GNIDA's dues are paid in full. So court was very specific that GNIDA first will be getting all their money. Only after that will the registration of units in the name of the allottees will start. Possession, not barred, but registration will happen only after GNIDA gets its money. And lastly, it says that another judgment that was there was kind of stopped. One important issue that I would like to add here is that the apex court in this judgment has once again endorsed India Bulls, Mansi Brar Fernandez and Regulation 36A, and the court has reinforced project-specific CARP as the norm in real estate, ring fencing viable projects and genuine buyers from other projects. So this is how the court has kind of revalidated those judgments as well.
So let us understand now what are the main issues which are resolved by the Supreme Court, which can be used in many other cases. So number one, the veil lifting in real estate group structure. That's what actually can be used in many other cases, whereas the authority leased land routed through subsidiary companies or special purpose companies or SPVs, the lessees can be drawn into the holding company or the holding company can be drawn into the lessee because it is the CIRP of the land and the project in one go. That's what is the lesson or learning that we have taken from this judgment, where the subsidiary or the holding is mere front and the home buyer's interest is at stake. So the second condition is home buyer's interest is at stake, but this lifting the veil is not applicable to many cases. It is applicable where the home buyer's interest is at stake because the home buyers are having the rights on the building, and whereas the land will cease its existence in case the building is constructed. So that is the logic which actually is said in a different manner. So it has it is saying that narrowing the separate entity shield, that sometimes is taken by the authorities and sometimes it is taken by the builders. So that has not been narrowed. So when we actually understand narrowing, that means the land and the project has to be resolved together. Then see the very important directions or the discipline is kind of required from authorities. The Supreme Court is also indicated that the public trust framing imposes a real monitoring and recovery duty on the authorities. Sustained inaction can forfeit penal interest because they were not taking any action despite all this information going to them. Penalties and time extension charges, though principal dues survive, and in this case the principal dues are also inclusive of the normal interest, compounded interest. But what is not entitled to GNIDA is the penal interest on four things: penal interest on a lease premium, penal interest on lease rent, penal interest on additional compensation, and the time extension penalties, which are huge. Then title versus possession clarified that reaffirms that the resolution plan transfers the development rights possession, not the lessor's title. The NOIDA or Greater Noida is not transferring the land ownership. They are simply transferring the rights, the contractual rights, which is the leasehold rights. The project-wise resolution is also endorsed. The Honorable Supreme Court has actually endorsed the judgments of India Bulls, Mansi Brar Fernandez, and that is also, as Ankit said. Again, I would say the when I saw that why the penal interest is not allowed to GNIDA. Now, in this case, the court has very clearly said that the GNIDA breached its own contractual obligation to monitor the project implementation. The Supreme Court says that in the agreement itself, the lease deed specifically provided for GNIDA would monitor implementation of the project. And the NCLAT read this as including a duty to ensure timely completion and initiate action against defaulters, which GNIDA has not taken. Having executed the leases, GNIDA failed to keep track and monitor the development being undertaken on such lands to ensure timely completion thereof within the stipulated period of 7 years, because originally the lease and the 7 years, because the lease premium was to be paid in 7 years. Then the second reason which was given by Honorable Supreme Court was its recovery efforts were sporadic and irregular. Like, see, even if there was a default, the authority was not regular in their actions, even their recovery actions. They were not regular. They were giving notices after so many years. So then the public trust doctrine was also used, drawing the spirit from the Noida Entrepreneurs Association versus Noida. The court treated GNIDA's statutory power as a trust coupled with duty to be exercised in larger public and social interest, with which a public authority cannot play fast and loose. Then the Supreme Court also said GNIDA had prior knowledge of developer agreement with subsidiary companies. Now the GNIDA cannot say that we had no information that the development is being done by somebody else. We only had 3 lessees and we were only dealing with them. We were not dealing with EIL, whereas there are very many evidences that they were also dealing with EIL and Earth Infra. So it failed to participate into the CIRP process. That's all the reasons given. The GNIDA is basically also responsible for all this litigation. So therefore, the principal, in fact, is being paid in full. The second thing which is in favor of GNIDA, that the full principals are allowed. Full principal, although the resolution applicants had consented in the court that they would be making full payment of the authorities. Full payment, full principal amount. But the principal amount includes normal and compounded interest. What it does not include is the penal interest. So one scenario, the GNIDA is definitely entitled. One thing which is clarified by the Supreme Court, that the registration of the flat in favor of the allottees, that would only be done by GNIDA in case full payment is made to GNIDA, or it will only be allowed by GNIDA once the full payment is made to them. So therefore they are entitled to full payment, then only the registration would be done. So this is, Ankit, something which is very important. Then again, I would say that think of a situation that in case the principal amount, as I have already discussed, that as far as the principal amount is concerned, there is a possibility of 2 disputes. One, the court has actually directed that the authority will submit their claim of principal dues. But the definition of principal dues is not very clear. Although in the examples it seems that it is only waiver of penal interest, but the normal interest, normal compounded interest is not waived. So that is again going to be a dispute, but because in the third project, where the total outstanding dues are still 250 crores, and I am not sure whether this SRA will give that. And one undertaking they have already given that they will not recover this amount from the allottees. So therefore, additional burden of 250 crore in one of the project may bring further litigation in this case because of this definition. And otherwise, this seems to be a resolution for many issues which are there. Most of the litigants and most of the real estate developers and allottees are struggling with. So, any other important part of this judgment, Ankit, that you have seen?
So I believe, to sum it up, it's very important to say that this judgment can be used very advantageously in a few scenarios. So one, of course, wherever the land owning company was a subsidiary of the corporate debtor, and there was these similar difficulties that are, of course, arising in this resolution plan, of course, there's a direct application of this judgment on all those cases. In my opinion, there is also an applicability on structures where the lessee companies are part of the same group, and they are not subsidiaries though, but they are part of the same group. Even they would be kind of part of the same structure, or the way the apex court has kind of pierced the corporate veil. It will be possible for even those structures or those companies to pierce the corporate veil and propose resolution plans that also deal with the rights of the lessee company, which is a company which is not even a subsidiary of the corporate debtor. It is possible to extend it because many times the agreements are structured in such a way, the promoter holding is in such a way that it can be very clearly established that these are part of the same group, and the the lessee entity also does not at times hold any other asset or any other business other than that asset itself. So this is where I believe this will be extended to. There is always a possibility to kind of use the interpretations of this judgment for other models also, where the land lessee is a different entity, it has different promoters, and the corporate debtor which has defaulted to Homebuyers is a separate entity. But there again, it will depend on case to case as to how that is applied. Penal interest, I believe, based on this judgment, maybe many resolution professionals or various resolution plans where implementation has not happened will try to understand if similar facts are available to kind of discharge themselves from the penal interest. In my opinion, that becomes a very large part of what is due towards GNIDA or NOIDA authority in almost all cases. So relief from the penal interest will become a big win.
So one advantage of this judgment to authority, may it be Noida Authority, Greater Noida Authority, Yamuna Authority, or any other land development authority, one advantage is that the principal amount is due to them. Now, because of the Amendment Act also, although this judgment was passed before the Amendment Act was notified, because this judgment is dated 5th of May 2026, and the Amendment Act was notified, I think, on 22nd of May 2026, and the regulations were notified on 6th of June 2026. So therefore, this judgment is before the amendment law, but still the authority was entitled to full amount, including interest. And secondly, which is actually held by this judgment, is that the authority will not make registration of units in favor of the allottees unless they get full payment. So these two advantages that the authorities are getting, the advantages that the builders and the allottees are getting is the clarity. And the third, the clarity which has actually been given by the IBC Amendment Act 2026, where the definition of security interest is changed, and also the explanation regarding the secured creditor and unsecured financial creditor is also provided. So these two things also make the authorities due are sacrosanct, that has to be paid. So this is where we say that in considering all this, most of the dispute actually will be clarified in real estate cases. So this judgment actually is going to play a good role in resolving all the real estate cases. Thank you very much. This is all. I hope you like this analysis. It's a detailed analysis. And if you like these kind of contents, please do subscribe so that the alert comes to you. Thank you.